would say the divorce process starts the minute that someone walks into my office for a consultation. Now, sometimes they do it by Zoom since we've been through COVID, and sometimes they may even do it by phone. But it's the minute that we have that first meeting that the divorce process starts, because that's the time I'm going to learn about you and your family. And I'm going to understand what hopefully you know about assets, liabilities, the finances in general, what your relationship is with your children, what the other party's relationship with your children is also. So who is, for example, the primary caregiver? Who takes the children to the doctor or goes to the parent-teacher conferences or works with, the other parents to organize play dates, does the homework with the children, picks up the children from school, gets the children to the bus maybe in the morning. I'm going to learn about that during that first consultation. I'm going to learn about how you co-parent. What is the demeanor in the household? Is everyone just frankly yelling and screaming at each other? Or is it calm and very civilized? How are you co-parenting with the other parent? I'm also going to learn about what the income is of each of you. And so I usually ask, what are the assets? What are the liabilities? What is the income? What does it all look like? And then we go through the process of what will it look like later. And obviously I don't have that crystal ball. If I did, it would be great, but I don't have that crystal ball to say what absolutely will happen. But I can give a range usually of what will happen in a particular matter based upon experience and based upon, what I know in terms of case law and what area you may be in, which county you may be in, what certain judges may think, etc. And then we will finish the consult and either someone will retain me or not at that point or go and think about it and have other consultations. If the person retains me, then we get started. And we get started as if we are preparing for two things simultaneously: settlement, or if it's not settled, litigation. And by the way, just because we're going into litigation doesn't mean that there may not be a settlement at some point during the litigation. And we will be preparing the case as if we're doing both, which means we will be gathering the documents from you and from your spouse. We will be sending out discovery demands. We will be taking a deposition perhaps. We will be putting together a settlement proposal, depending upon whether we know enough to do that, whether you as the client know enough to do that. That's the big question always. We want to put together a settlement proposal that takes into account that you know what the assets, liabilities, the support that you'll need, the support that actually supports your lifestyle to some degree. And so we put all of that together and we get ready for either a settlement or litigation. And we take it all the way until there's a settlement. That means doing the discovery, sending out the notices, doing the net worth statement, sending out deposition demands, doing a deposition, perhaps having conferences in court, perhaps having settlement conferences, doing all of those types of things. And then hopefully we reach a resolution. And it's so important to reach that resolution because trial is an expensive process. And so we try to reach a resolution in many of our cases, and in many we succeed, but in the ones that we don't succeed in reaching resolution, we move forward to prepare for a trial. We gather our exhibits, we outline our testimony, we work with our client, we prepare our client for what they're going to feel like in that courtroom, and then we actually conduct the trial if necessary.